following back up on this series on life planning and thinking ahead and what are the benefits of a medical power of attorney and a Texas durable power of attorney. So they're two different documents. They're inexpensive to draft and they can only be signed when somebody they have all their cognitive factors about them. And you don't have to have a great deal of mental capacity to execute powers of attorney or a medical power of attorney. However, you have to have enough, basic things like, what day it is, who the president of the United States is, and, it varies, but your loved one has to have their faculties about them. And when they don't, these documents are, that's just out of reach. It's not something that can be done. And sometimes there's moments of lucidity. Those are hard to capture. It's hard to find those people. And, it's very unfortunate because people sometimes, they can articulate what their wishes are, but when it comes time to sign the documents, they're not there. They're not there in a significant and meaningful way that it's clear that they understand what, if at all, they are signing. So it becomes very problematic. And, no matter how much your legal counsel wishes to help you, it just becomes impossible. So think ahead, plan ahead, get these documents executed. When your college-age kids are going off to school and driving across the country, get these documents executed so that way you, the family member, the loved one, are in charge of them. If they get hurt in an automobile accident, you can communicate directly with the medical care providers and make decisions for your loved one. And it's not something that parents wish to think about, but a power of attorney gives a parent of an emancipated minor or adult child who may be commuting to the University of Alabama or Arkansas or what have you, and they get in a terrible 18-wheeler accident and they're blacked out in a coma. They're 21 years old. You're just the next of kin. You have no right to make medical decisions for that individual. At that point, you're just the next of kin. Now, sometimes and often the medical care providers will listen to you. They don't have to, but if you have a medical power of attorney and it's valid and executed correctly, they have to. You're in charge. You're the medical power of attorney. And it gives you the right to act on behalf of that loved one. And that's why a medical power of attorney is critical, especially before our elders age out and they lose capacity, and especially before some bad accident occurs and you're not able to assist an adult in their life care decisions because they're over 18, right? So these are just simple things. Think about it, get it done. Okay, back to the other power of attorney. The Texas Durable Power of Attorney is a power of attorney form. Again, not difficult to fill out, not difficult to designate who you want to be in charge of your financial situation. Should something happen to you, should you lose capacity on a temporary basis or a permanent basis. But as we are all getting older, this is something we need to think about as we travel to distant places, as unforeseen events can make a hiccup, a kerfluffle, or a huge problem in your life. Having a power of attorney that puts someone else in charge of your financial situation, whether that be a spouse, a sister, a brother, a mom, a dad, a loved one who will put your best interests in heart in front of their own, because they do become a fiduciary, and they have to acknowledge that they realize they're becoming a fiduciary on that form, and a fiduciary is in a special position of trust and is held to a higher standard of care because they are in a position where they could do significant harm to you if you were temporarily incapacitated or permanently incapacitated and they were not a good steward of your financial resources. So, but what's critical about these two documents is they circumvent the entire guardianship process that I touched on in the first part of this series, and that can save families thousands and thousands of dollars, because if a guardianship is put into place, there's the whole lawsuit part of that where the applicant has to petition a court, a couple $100 in filing and service fees, $1,000 in attorney's fees or more, $2,000, $3,000 to get through that process. Then the court appointed investigators and ad litem for the ward have to be appointed and paid all out of the ward's money or the applicant's money, and then seek repayment. You know, the applicant seeks repayment after they get made to be the guardian of the person and the estate. And then you have to manage that estate in such a way that complies with court orders on a budget or whatever it may be, and report to the court on an annual basis. More legal fees, more issues, and none of these are insurmountable, but they are costly and time consuming and problematic. So it is a scenario where legal fees can be avoided and eliminated just simply by having these two documents in place. So think ahead and get them done. Anyway, hope this has been of some help. Get your powers of attorneys in place. It's just something that we all need. And as we're walking around, we just don't know where you might be in a situation where, again, that young child driving off to college who's an adult, who no longer is, you don't make decisions for anymore just because you pay their health insurance. You're just the next of kin, or husband, wife, sister, brother, mom, dad, aunt, uncle. Have somebody in charge of their medical decisions and their financial decisions should they become temporarily or permanently incapacitated mentally. And that is just something, it's a safety pin that you can't get back when somebody has lost capacity. That the opportunity to make that protection for that person once they have been in that car wreck out of state on the way to the university or what have you is gone. Or grandma or mom or dad has lost capacity because of mental age and disability. There's no way to get that opportunity back. If they've lost capacity and they cannot be lucid enough to execute a power of attorney, that opportunity is foreclosed. And then the only thing you are left facing is that long, arduous probate court application for guardianship, which again is costly. So I just advise you, try to avoid that at all costs if you can. But don't be afraid of it, because the courts are very kind about it. You know, it's not meant to put fear. It's simply just a preventative step that's easy to take. So, but don't be afraid of the probate process or the guardianship process. It's just time consuming and it can be costly, but it's not impossible or daunting. So I hope this has been of some help. I hope you're never faced with this scenario, but remember, just get your life planning estate, especially your powers of attorney, in place as quickly as possible. Anyway, please like, subscribe, and share. I would appreciate if anyone has a comment or question, leave it on the comment section of any social media platform you are watching, and I'll either reply to it directly or make it the subject of a subsequent video. And with that being said, I'm going to jump into some other topics regarding estate plans and some myths about estate planning that I hope will clear up some of the misconceptions that I think people have regarding estate plans, certainly in Texas, and how estates are administered after a loved one passes away. Anyway, please send me your comments, and I love doing these videos for you and look forward to doing them again. You can see I'm back here in the studio, and I'm absolutely thrilled to be back here in the studio doing these. I hope you like the ones from the road. I'll do some more of those as the months pass on. But right now, without further ado, I'm going to do some myths about estate plans.